behavior of the employee which violated company policy. Section 41, you all still remember, if any employee misconduct, then we can investigate under section 40. Because section 40 allow for termination on the grounds of misconduct. Misconduct divided into two categories, minor and major. Minor HODs can manage at the initial stage. Major HR involvement, immediate HR involvement is necessary. Okay? So major means serious, like theft, dishonesty. You can check the list. Usually we will suspend them pending investigation, DR, and then depends on the panels what's the finding and the recommendation. Okay, that's major. Minor is less serious, like occasional tardiness, frequent latecomer, okay, or absence. Is from the wing. Immediate HR involvement is not usually required. So HOD can gather the evidence before go to the HR. So you all can give the ECR, okay? ECR and just counseling. After ECR, can ask HR to issue warning letter, because in the ECR document itself there will be an option what you want to give. Just verbal warning also can, or just take first warning, second warning. Okay. If the misconduct persists, then need to issue a show cause letter, proper process. Show cause, DR, then the decision depend on the panels after finding. Okay, let's see this case. What happened in this case? Okay. This case is whether the dismissal of the claimant for the misconduct is a insubordination event. Insubordination means he didn't listen to his supervisor. Pembuangan kerja. If any word not sure, just translate. Okay, pembuangan kerja Encik Muhammad Saiful. Okay, claimant in Malay we call pihak menuntut. Company pihak hospital. So bila buang kerja 16 Mei 2014. Okay, let's see. This is quite funny lah this case. See what happened. This Encik Saiful mula bekerja 16 April tu lah. Dia datang pukul 9 pagi. Lepas tu dia register nama dia nak mula kerja. Tapi supervisor dia, COW means company business, immediate supervisor dia cakap dengan dia, nama you tak ada senarai untuk shift pagi. Kita ada cukup orang. Pukul 1 je you punya shift start. Balik. Okay, lepas tu dia tak happy. Kejap-kejap beberapa kali dia pergi dekat supervisor dia. Lepas tu ajak minum keluar. Okay, you know right why dia ajak minum keluar, and then mengeluarkan perkataan-perkataan yang ancaman. So that's the case about him. Later you will see lah what are the words he used. And then that's the main allegation, insubordination, because dia tak dengar what the supervisor instruction. So then pihak hospital tidak berpuas hati dengan penjelasan yang diberikan dalam siasatan dalaman dari Encik Saiful, and then so they dismiss him lah basically, because got 6 witnesses against him, not 1 to 6. Okay. Si panel siasatan dalaman mendapati beliau bersalahlah atas pertuduhan. Okay, let's see. Okay, this is so after the dismissal, he go appeal to the CEO. CEO also say no, your appeal is rayuan dia ditolak. Okay, now let's see the context. Now the court want to see whether his misconduct, salah laku, dikatakan oleh pihak menuntut bukti atau tidak bukti. Kalau bukti, then dia punya penamatan atas alasan adil atau tidak adil. So that's the court duty. So what want to see? Okay, let's see what he did. Okay, these 6 people are 6 or 5. 5 people are witness for this case. They all witness what he did. Okay, COW is Leong Wan Hee. He is their supervisor lah. Okay, keterangan kan. Pihak menuntut terang on the day he supported, right? His duty roster 1 PM to 9 PM. Walau bagaimanapun, on that day he came at 9 AM merekodkan kehadiran untuk melakukan overtime. And then the COW1 nasihatkan tidak tersenarai dalam jadual kerja lebih masa, and then beliau tidak diperlukan at that time 9 o'clock. So since he not happy, semasa berjalan ke biliknya beliau terdengar, and this guy call him Abe. See, everything we already know. After that, he's not stopped there. After that, 9:20, he go to his office, the HOD office. Okay, saya dah lama bersabar dan selama ini saya diam dan you kacau beliau nasi orang. Okay, and then he call him now to fight. So pada masa all these the witnesses all listen and see. So all those people testify in the court. So pada masa yang sama, pihak menuntut ni sekedar juga mendakwa HR okey je I kerja lebih masa. He say like that. Why supervisor you are not allowing me? HR okey je. See, then mencabarlah siapa besar, you kah? Atau HR manager, siapa besar? All these ancaman. Certain words. We cannot ancaman besar big offense. We cannot do that. Then selepas itu he remove his my button he remove his clothes and then mengajak jom same waiting for you there. Saya tunggu. Then he felt threatened already. He cannot tolerate anymore. Empat lagi dia pergi. Sebabnya shift dia dah start kan. Dia pergi ambil 2 hari MC lagi. So walaupun beliau tidak mempedulikan, pihak penuntut masih lagi ke pejabatnya dan kali terakhir adalah pukul 4.15. Tetapi ketika itu beliau sedang menghadiri syarat the supervisor in the meeting. So all this meeting fine. So si pihak menuntut telah mengancam dan menggertak beliau. All this court say the lagi perbuatan pihak menuntut juga menjurus kepada insubordination. What is the threatening insubordination? Because despite he say the supervisor say your shift is at 1 o'clock, so you cannot work. That's insubordination. He didn't listen to the instruction. So he complained kan. See, and then on the same day pihak menuntut telah tidak bekerja dalam shift biasa kerana cuti sakit. So he's contradicting himself, you know. Cuti sakit, then he's supposed to be in the house, right? Yang semua court tengoklah sebagai evidence. Walaupun beliau telah diberi cuti sakit, namun beliau masih berada di sekitar hospital sehingga untuk mencari masalah dengan supervisor dia. Okay? So that's the case lah. So let's see. Okay, so berdasarkan aduan, what HR did, suspend him. Surat pergantungan. Suspend him sementara siasatan dijalankan. Okay? Now, this one, the claimant, the employee case, in the mahkamah, what he saying, he didn't make any saksi. Only company has 5 saksi. Okay, of course, no one will go for him, right? Because he say many people saw it. So dalam keterangan beliau, what he said to the court, on that day, he registered the book, overtime book, sebelah pagi, kemudian telah dimaklumkan oleh supervisor dia tidak dibenarkan untuk melakukan kerja lebih masa. Okay. And then kemudian memberitahu semasa ketiadaan. Okay, this one is another person. Basically what he is thinking. Another person, COW, don't know who is he. He's not his supervisor. Ask him to work for the overtime. Basically he's lying. And then he said he admitted tidak berpuas hati dengan arahan yang diberikan oleh supervisor untuk mematuhi jadual kerja lebih masa yang telah disediakan. timbangan dan kebarangkalian, balance of probability in Malay. Penamaan kerja pihak penuntut dalam dibuat sebab atau alasan yang baik. Okey? Dengan itu mahkamah menolak tuntutan. Okey, that's a misconduct. Misconduct, right, what he did. Okey. Sekarang poor performance. Okay, for misconduct, always remember this process. Disciplinary process. Misconduct, always remember, find the facts. Who need to find the facts? HOD. Then bring to HR. HR will do suspension if necessary. And then HR will issue show cause letter, conduct domestic inquiry, then decision. Okay? This is the mandatory process. Next, poor performance. Okay, poor performance not specifically mentioned under section 40 sub 1. They only mention misconduct. But poor performance also will come under the section 40 sub 1. Okay, poor performance means failure to meet job expectation. Your this one purely related to job, not related to your action. Action means misconduct. Okay? So, for the domestic inquiry, not required. So, we need to put the stuff under VIP. Performance Improvement Plan. So, during VIP, must clearly communicate what is the expectation, give fair chance to improve, must coach, must guide, must give deadline. On the deadline, must call the employee, check whether comply or not comply, give first warning. Okay? they changed her department, another department, and finally they changed to a audit department, which she has no experience. Okay. See, she was employed as a branch executive initially in 1996. Monthly salary 2,350. When dismissed, her salary is 24,000. See, the claimant claimed that she had handled many roles over the years during his tenure of employment. In January 2021, actually he or she, I don't know, here is she, there is his. So I confused myself. Male or female, technically. Oh, I see number, so female or male? Oh, I see number. I see number, I don't think so. I see number, I don't think so. It's a PDK, right? Tung Yok Leng. Female. Female, huh? So this one now, she. So, see, she initially seconded to audit department. Then the problem started from here lah. It is not here but please. So we confused. And here got she. Okay lah, couple human being. Okay. So, January 2021, she was initially seconded to audit department, then she need to manage the department. Okay. So, prior to transferring to this department, zero knowledge, okay, or experience in audit. Totally zero knowledge, no experience, but she need to manage the department with lot of KPI, no training, nothing. They supply resources, all are inexperienced, newcomer, probationer. So she need to manage them, she need to manage the KPI. Finally, they terminated her. That's the gist of the story lah. See, then, see, January only, right? January 2021, they transferred her to the audit department. Key point here, zero knowledge in audit. June 2021, she was placed PIP. Not there, right? June, within few months, PIP. Yeah, it's totally not fair. Okay? So, she's not performed, was not satisfying for the first 3 reviews. Okay. However, the fourth review, the company found that the claimant met all the VIP The company, on the other hand, they say the claimant was holding the senior management. They just happened to get senior management position in the company and ought to be fully aware what was required. So the claimant joined internal audit division since 2012 as an individual contributor and has sufficient knowledge and experience to deliver complete the yearly KPI assigned to her. Okay, that's the argument lah. All these are I only read the important point. 2020. Okay. 2021 the KPI, they launched the KPI. Okay, the company said the claimant was noticed to have continuously failed to improve to the standard required by the company, even though the claimant was given sufficient time, assistance and guidance. You know, assistant all probation person, newcomer, no audit background. How they will assist her for the whatever pile up work? So they are burdening her, not helping her. So the company has no alternative but to terminate her. Okay, let's see what say. Okay, this one you need to know what's the law for the EIP. See, claimant, the company must prove if you terminate anyone under EIP performance issue, the company must prove claimant has been warned of his poor performance. That's the warning letter. After the certain duration, warning letter. Then claimant was afforded sufficient opportunity to improve, coaching, counseling, or sending training. Okay. Number 3, claim if after do both, still the claimant failed to improve the performance, then you can terminate. That's the law. Very clear that. Now, one by one, the court check whether claimant was warned. The first one, see, the warning, of course, they given 3 warnings, right? So the claimant, the warning given to the claimant need not to be in the form of warning letter strictly. They given warning, and then the claimant was complained about snowballing. Snowballing means many things to settle, but still I don't talk. That's the snowballing effect. The snowball go fast, right? So that's the effect. And no guidance or coaching from the company. She already emailed to them. The company did not adduce any evidence to support this claim. They have coached on that. They didn't coach, didn't they? So they didn't support their claim. Okay, all these are the judge given judgment. See, on the email sent by claimant, being the company's human resource partner, okay, in addition to the VIP, suddenly the HR manager sent an email to the claimant mentioning, 3 tasks sudah lupa, tambah these 3 tasks. Okay. They forgot to include certain the company did not agree with the claimant's counsel. Claimant counsel means claimant's lawyer, and she hired a lawyer, that if the claimant had been warned by the company of the enhanced PIP beforehand, she would have brought the company's attention the sooner the reason of her late deliverable and the problem she was facing, especially the snowballing issues. Okay, I think maybe she had highlighted to the company late she cannot manage all the tasks. Okay, second, whether the claimant was given sufficient opportunity to improve. Okay, see about the coaching. This is the coaching part. What the court noticed on this point, company submitted they had provided guidance and coaching and resources to work with the claimant during PIP. One of the company witness confirmed that all the coaching and guidance given was done verbally, not documented. Okay? Therefore, the company unable to prove that the guidance and coaching was done during PIP period. So, company is naive. They don't have anything. This is the best part. See, the company claimed they have allocated resources. 3 resources. First one, Ratri Soli, problematic stuff. Second, see all these are they just writing this. Second one, Nur Shahira under probation, new staff while assisting the claimant. So she also no knowledge how to help her. And the third person, Nadira, she is an IT auditor. No experience in anti-bribery and fraud. These 3 resources redundant cannot help her. Okay? One more person, final person, who just joined audit department after claimant was placed in that PIP. So after considering all this, court find company has not been fair to the claimant. Company claims provided support staff, but staff with no experience and then added to the task to the claimant with PIP. Then she has to manage the staff and also the PIP. Added staff, right? So she had to coach and guide the new staff. How did the company expect these support staff to help claimant to reach the KPI when they need the coaching and guidance from the claimant herself? Can you see how the court look at the cases? Very tedious. Okay. So finally, of course, the third for them, she failed to improve her performance. That's why we received termination letter lah, dismissed. So finally, the court that's the amount that the court say. So the claimant worked for the company 25 years. So she joined 1996. Of course, no money. All this year, no money. Up to 2021, problems started. Okay? She worked there without any complaints. She's a good staff. Okay. Then they say the entire process PIP company failed. Coaching and produce evidence. So the decision after evaluating all the witness everything, company must not done in the good faith, bad faith. So, $1 million lah. Jackpot kan, $1 million. Masuk FD, ambil monthly interest, hidup senang. Kan? See, 25 maximum 25 years, 25 months. That's the monthly salary is 1 year, 1 month. 1 year, 1 month. There's a compensation in lieu of reinstatement. This one back wages maximum permanent staff 24 months. Times in the labor department straight away your grievances down or HR. If you're not happy, the way investigate, you can always go to labor department. Okay, so must handle it. We have policy, grievances policy. Yeah. So just follow the policy. Okay, first one is misconduct. Second one, stealing, misconduct. Third one, poor performance. Fourth one, very good, obedience. Okay. Number 5 is misconduct plus offensive language. Okay, offensive language. Okay. Quality of work. Number 9, KPI. Poor performance. Number 7, employee denied grievance. So all of this one is grievance. Because you are not happy, you said that you can inform HR, HOD didn't approve my leave, already planned, something like that. Number 8, sleeping. It's an action. Misconduct. Okay, number 9 has received lower. Which one? Yes, very good. Number 10, refusing to follow lawful instruction. Refuse to follow instruction from the super. Misconduct, tadi insubordination. Ambil. Tadi one insubordination. Okay. An employee is frequent absent without notifying. Misconduct. Number 12, you complain unsafe grievance. Grievance because you are not safe. Accidentally damage equipment due to lack of skill. Poor performance. Okay. Employee number 14 refuses to attend training session without earning. Misconduct because insubordination. 15, employee is considered underperforming. And poor performance. So, employee feel harassed by the supervisor repeated rude remark. Grievances. So, employee got falsifying timesheet. Misconduct. Employee works slowly due to lack of proper training. Poor performance. Employee uses company equipment personal use. Misconduct. Employee is overlooked for promotion despite meeting grievances. Okay, so you will be fixed at that. Next one. 100 See, got one more exam, the one later. No, not exam. Just activity. Sempat buat sini, otherwise you are doing back the school lah. Just for your knowledge. It's all about MCQ, Employment Act, IRA. Okay, now understanding employee dismissal, termination, contract ending. It's very important. Okay. See, there are types of how the contract ends. The first one is termination. Like tadi kan, section 12, you give notice 2 months, or the employer can give notice 2 months. 13, willful breach. 15, deemed to be broken. Award. Okay, that's termination. Dismissal, section 40. Due process, misconduct, DI, poor performance, PIP. That's section 40. Dismissal. Probationary dismissal. Probation people person. If you dismiss, that we call as a probationary dismissal. Retirement. What is the minimum age of retirement? 60. Okay. When they officially there will be a document for the minimum age of retirement in 2021. Prior to that, it's just a 60 way of saying there is a case. It's a doctor. 70. Minimum is 60. We can work lah because some of the professor 70 need that person or certain project. If any of the position is permanently there, renew, then the court see it as not a genuine fixed term. I will show the judgment, how the court, how the law. Okay? Okay, before we go there, you need to know certain words. For the dismissal cases, burden of proof, employer on employer, dismissal, normal dismissal. For the constructive dismissal and also forced resignation, employee must prove the company did this so that I resign. For normal cases, misconduct or performance, company must prove. Standard of proof is balance of probability. You just need to convince the chairman 51%. If you successfully convince the chairman, then you will win the case. Okay? Now, we understand dismissal of probationer. We learn what's the rights of the probationer. If we want to dismiss probationer, what legally we should do. All of us know probationer is the person who is learning, okay, on trial basis. Because the employer want to evaluate, want to see whether that person is suited for the work. Second, does the probationer enjoy the same rights as permanent employee? What do you think? Probationer. If dismissal must undergo proper process. General rule, probationer means no right to permanently hold the position because they are under trial. But if you want to dismiss, non-confirm that person, you must justify. You must justify. Even for any unfair dismissal, must go through the proper process. Misconduct means DR, performance means PIP. Okay? Employer cannot terminate a probationer without just cause of excuse. The procedural fairness still applies to them even though they are probationer. Okay. Next. Sometimes employer tend to forget to issue the confirmation or non-confirmation. That's happened because so what the law says, if the probationer continue to work without any express confirmation or extension, the court interpret it to be deemed confirmed. Menganggap sebagai sudah confirmed. That's the law. This is the judgment. See, an employee who is neither confirmed nor terminated at the end of his probationary period is deemed to be confirmed and automatically entitled to all the benefits that come along with the confirmation, as stated in the terms of the employment. But our policy say we must issue letter, right? Policy decided cases still prevail. Yeah, in offer, you all mentioned the offer letter. But when there is a dispute, case law will prevail. Case law means decided case. earlier. So meaning to say they need to be confirmed. Later we cannot say you are not confirmed.
But labor code is different. Labor code is refer to the offer letter.
Yeah, offer letter, but they don't strictly follow. They will see the how long this person didn't issue the letter, how long she's in the system without issuance of confirmation letter. Yeah, so that's how they look at it. They don't treat as though as civil court. Burden of proof, must the employer prove poor performance or any misconduct dismissal? The employer must prove. Okay, let's see this case. See, for the poor performance, dismissing the burden.
If the HOD is only communicate to the poor performance staff during evaluations on monthly basis, final email is still required.
Email is one of the
Of course, we need the staffers, undertaking the staff that will send through the email to confirm, okay, this is what we have discussed.
Yes, okay, that's one you already communicated. But the deadline, everything clearly communicated, and also you must give counseling. Counseling is very important. It's two very important. Then you can make a decision after given chance.
So whatever type of document that has been done by the HOD is actually valid as long as they have to put the target, the specific target, what you need to complete, what you need to do, right?
But I would advise you to use the VIP form.
Or
We have VIP form, right?
but what is other provisions?
Yes, can.
Probation, you have to pass a 6 months or 3 months probation, then you can start to use the VIP, right?
Yeah, must give them some duration to learn the work. Cannot immediately. Then you must extend their probation period. Okay. See this one. Can the service of a probationer be terminated? Just now you asked, right? Before the probation period ends. Can or cannot? See, the probation period is 6 months. So how the court look at it? See, they say a claimant placed on a probationary period for 6 months could not be judged on the suitability to employment within a period of 1 month. So it appears clear to us that without anything more an appointment of probation for 6 months give the employer no right to terminate the service of an employee before 6 months. So we must wait for the probation period to end. Unless there is a misconduct, serious, major, then yes. Okay. So necessary to give warning? Yes. We must follow the process. Okay. See, even in a trial period, a worker should have some warning. If some warning and a trial is not proceeding well, there should be some notice, some warning, some opportunity for discussion and explanation concerning any alleged deficiency. But not immediately now, like you say, like after 3 months is a reasonable period. Okay. Is failure to give warning is fatal to the employer case? So what the industrial court decision they had, we must always make sure proper warning given. Because without warning, they wouldn't know what lacking on their side. So warning is important. they decided. Then now when they terminated, the claimant now is pleading to the court reinstate. You want the job reinstate. See, in his pleading, the claimant seek for reinstatement. So the company argue, what the company breach of contract by the employer and also cutting your salary that discussed with you. All those are going to root of your contract. That breach must be sufficiently important to justify your resignation. Simple breach all cannot justify. Make sure it must go to the root of your contract. In major breach, he must leave in response to the breach and not for some other unconnected reason. When you constructively dismiss yourself, make sure you dismiss for that reason, not for different reason. He must not delay too long. Don't think for 1 month whether want to constructively dismiss or not. You must do it immediately because of the gap. which was to be paid by the hospital. So meaning to say salary remains same. So but he's not happy. He's not happy because transfer and jadi manager. Okay. And then totally different. He need to promote the pelancongan. Okay. Then promotion he must go and talk to them. I also don't do that. Okay. So what happened? He appealed but rejected. Then he have to go down. According to the new department, they say he came for the first day punch card. But he's telling he didn't go at all. He constructively dismissed himself. Company argument he still under employment. His argument he constructively dismissed himself. Okay, let's see what say. Okay, before that, let's see what is constructive dismissal. What the law says, law. Because when I share all this with you, you read the law part. Forever remains same. Then you all know. Constructive dismissal means employer is guilty of conduct which is significant breach going to the root of the contract of employment, or which shows that the employer no longer intend to be bound by one or more of the important term of the contract, then the employee is entitled to treat himself discharged from any further performance. If he does so, then he terminates his contract by reason of the employee's conduct. He is constructively dismissed. The employee is entitled in those circumstances to leave at the instant without giving any notice at all, or alternatively he may give notice and say he is leaving at the end of the notice. But usually God will your position in that new department